Hello friends, in the series on the income tax cases, today we will discuss the case of Principal Commissioner of Income Tax versus Kimberley Clark Lever Private Limited. This case has been reported in 455 ITR at page number 576. The matter has been decided by Bombay High Court and the date of the judgment is 7th June 2023. Friends, this case is a unique case, as all we know that reference to the transfer pricing officer under section 92 CA can be made only when the assessment proceedings are going on, or in nutshell, until and unless the assessing officer has issued the notice under section 143 subsection 2. The assessing officer cannot make reference to the transfer pricing officer to give its report. But in this case, there was no assessment proceedings were going on against the assessee, but the learned assessing officer sought the report from the transfer pricing officer. Both the income tax officer and the transfer pricing officer made a fundamental mistake. The first mistake was on the part of the learned assessing officer to sound this report without going the assessment proceedings. And the second mistake was on the part of the transfer pricing officer to give this report in the absence of any income tax proceedings. When this report was given to the assessing officer found that according to that report, there is some income escaping assessment on the part of the international transaction with the associated enterprises. And on the basis of that transfer pricing report, the assessing officer issued notice under section 148 to the assessee. When this notice was issued, the objection was raised by the assessee that my notice under section 148 has been issued on the basis of a transfer pricing officer report which is bad in law, because that report cannot be sought until and unless my assessment proceedings are going on. So this notice is also bad in law. The assessee also quoted the instruction number 3 of the Central Board of Direct Taxes dated 28th May 2003, which specifically says that the assessing officer cannot seek the transfer pricing report from the transfer pricing officer until and unless there is assessment proceedings going on for the assessee. So when this notice was issued and the objections were not entertained by the learned assessing officer, the assessee went to the writ court, and the Bombay High Court said that in this case there is a mandate of section 92 CA and section 143 subsection 3 that without the assessment proceedings get triggered, you cannot go to the transfer pricing officer and seek the transfer pricing report. And in case this report is sought, then that report is null and void. So if you have sought any report which is not have any legal backing, you cannot use that report for initiating the action under section 148. So in this case, the transfer pricing report is null and void, and on the basis of which the notice under section 148 has been issued is also bad in law. Friends, this case is very important because sometimes it happens that whenever any notice comes, we start participating in the assessment proceedings without going into the integrity whether this notice is valid in the eyes of law or not. So because there are a number of laws and there are a number of procedures which the assessing officer has to follow before getting into the assessment proceedings, so we have to check all those points and all those steps whether the department has taken all those points. So in this case, the assessee well noted that the transfer pricing report was sought in a illegal way, and that report cannot be used by the income tax department for getting triggered the assessment proceedings under section 147 read with section 148. Because the basis of issuing the notice is illegal, so hence all the assessment proceedings are invalid and the notice is also invalid. At the end of this video, once again, I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus Kimberley Clark Lever Private Limited, and this case has been reported in 455 ITR at page number 576, and the matter has been decided by Bombay High Court, and the date of the judgment is 7th June 2023. Thank you, friends.